Today's guest is Dallas attorney John Schorsch. John has tried complex, high-stakes cases in courtrooms across the country, from financially tangled family law battles to business disputes, injunctions, and catastrophic injury cases. And he's argued cases all the way up to the United States Supreme Court. John is known for his courtroom precision, his strategic calm in the face of chaos, and his ability to see 3 moves ahead when the stakes are high. If you want insight from someone who's seen how power, money, and conflict actually play out in real courtrooms, this is a conversation you don't want to miss. Hello, everybody, and welcome, John Schorsch. I am so happy to have you here on Out of Crazy Town. Thanks for joining me.
Jackie, it's my pleasure to come to Crazy Town. I thought I already lived there, but apparently I didn't.
You work there. You work in Crazy
there.
Town.
I'm a hostage there.
You are
I'm
a
hostage at Crazy Town.
I hope at least you're getting paid. So I just
No, my ransom has not been paid yet.
Oh my gosh. That's how I think a lot of the people think or feel that are listening to this podcast, that they are being held hostage and there's a ransom. So, and usually it's something awful like their kids. But anyway, we'll get into that. So what I want people to know is that, I'm really glad you're here. And you have spent decades in high conflict, high stakes courtrooms, handling everything from complex family law cases to major business disputes and appeals. You've tried cases to judges and juries, represented high profile and high asset clients, and seen firsthand how people unintentionally hurt their own cases, especially in divorce and custody battles. So today, I want to dig into the strategic decisions that actually help people gain ground and what courts really pay attention to, and why sometimes the smartest move is saying less, not more.
I think all of that's true. And I also think that many of the strategies that I try to impose on or get my clients to buy into are helpful and healing strategies emotionally. It allows them to make it from one spot to the finish line in an emotionally more stable place, or to recover faster because they've been building up calluses doing the things I hope that I tell them to do that are right for the moment.
Yeah. And it's got to be such a different animal, because I know you practice other, areas of law, but you have to treat the whole person, I would think, almost like a physician when you're dealing with family court cases versus, oil and gas.
Well, it's true. It's holistic. It's holistic in those cases too. People forget that. And oftentimes it's the human element that makes the difference in what would otherwise be a numbers case. Whomever the trier of fact is, oftentimes in family court, it's a judge. It's a rare thing to have a jury. In other cases, it can be either, and often has been, that person or persons, they have to believe somebody. Yes, you can put numbers on a board, but at the end of the day, they believe somebody's story, and the human element, that empathy, bringing out that person and who they are, makes a difference.
That makes so much sense. And so let me just start with a broader question. What are some of the ways that you see people sabotage themselves in family court cases?
Well, the problem is they don't get professional assistance soon enough. And I don't just mean a lawyer. I mean mental health or family support that's objective, or self-help, creating distance and avoiding high temperature conflict. And they oftentimes don't go to lawyers soon enough. We're called lawyers and counselors for a reason. And if all of us did what some of us try to do, which is to see the whole person as one part of a tapestry, and to know that at the center of that tapestry is that person, and if there's children, that person and those children. There's a thread that ties them together, and there are threads that used to tie them with the other person, and they've been frayed or ruptured, and you have to kind of identify that early. And if they don't come in soon enough, they may have inadvertently self-sabotage, because we all try to defend ourselves and to defend our position, or to defend what's left of our dignity. And that's really where the problems start. They don't know soon enough what hurts.
Yeah.
And not just the law case.
Sure. Long-term damage, just all around. Yeah. Because in many cases, obviously, if there are children involved, you are tied to this person, to your point of threads, whether you like it or not. And so it's very complex.
You're tied to them. They forget the decades to come, and they look at the years that have passed. And that's a very hard trade. The amorphous decades is a hard trait to understand when you're living through the days, the weeks, the months, and the years of oftentimes very painful emotional distress.
Hmm. Hmm. So let's get specific. So a client comes to you and maybe they did wait a little too long. What are specifically some of the things they've done that you're either trying to undo or counsel them away from doing?
Oh, they've been drawn into a minor physical skirmish. Happens
Mm,
all the time. Somebody throws a notebook across the table, the F-bomb and every creative variation of it is accompanied by one side or the other. And maybe the notebook gets thrown back, and years later, that's, like the Kennedy assassination.
yeah.
It's not, obviously, it's human beings acting in the moment. People try to create evidence or to preserve evidence when they don't know the rules.
Yeah.
And then the evidence they try to create sounds created rather than organic.
Yeah.
By that, I mean, if you're having a fight with your spouse or your loved one, and it involves the children, and the children are being besmirched, or your parenting is being besmirched in a way that's damaging. It's in front
Hmm.
of the children, or it's damaging to the psyche of your client. You've seen it from the mental health side.
Yeah.
If you just had a film camera rolling in the background, boy, that wouldn't be that great. What people start to think about it that way, and then they start to self-sabotage because they set things up that way. And they try to preserve it, and the preservation of it goes sideways, and one side figures it out, and now they've entrenched. Now they're moving further and further apart, and the evidence is useless. I see
Okay.
that, and I see people doing illegal things. They don't know it's illegal. I know he or she has a girlfriend or a boyfriend, respectively. I know it. I can prove it. I'm going to put a tracker in their car.
Yeah.
And I'll be able to then take that tracker and compare it to a Google map because
Yeah.
I just know he's seeing that dancer or she's seeing her old high school boyfriend. That's illegal.
Right.
Or putting remote recording devices that you're not a participant in. Some states are what are called two-party conversation states, where only one person has to give consent. Texas is one of them.
Mm,
So if you and I were talking and you were my spouse, I could record you without telling you because I gave permission to myself. You could do the same to me. Other states, oh no, everybody
California,
has to be
no.
informed. And if it's a
Right.
three-party event, the third party always has to be informed.
Mm.
It depends on the state, and people don't know that, and they harm themselves because now they have an illegal act that if they're asked about it, they have to be truthful about it.
Yeah, right. And that is such a good point because I will have clients that come to me and say, he or she's done all of these things, and I admittedly did these one or two things. What should I do about it? Because I know it's not going to look good in court. And I said, never lie. Let your attorney know and get out in front of it. If anything, if it's something that your attorney says the judge will care about, you say it first, whether it's in your declaration or whatnot. What do you think about that?
Well, there's a technique
Okay.
in trial practice. It's called, everybody's got a different name for it. I call it pulling the tiger's teeth first.
Okay.
So if my client has a problem or a series of problems, whatever it may be, I try to incorporate that into my examination on my terms. I want the story told in my terms. The author of the story needs to be my client and I want it to be sequential. I want to put the bad stuff out front on my terms first. So by the
Hmm.
time the other side is talking about it, it's old news.
Yes.
And it sounds like they're nitpicking when in fact the person's confessed.
Yeah.
But they've confessed in a way that's helpful because when you think back on it, they weren't trying to break the law. They were trying to preserve a moment in history that they were afraid they couldn't recount properly. That's
Yeah.
often really the truth of it.
Sure. Sure.
Um, there's a method that I've called the reverse Pac-Man. I had a lady who had several children and was carrying a child. And I didn't know it at the time, but she had some severe mental illness. I didn't know
Mm.
she had organic mental illness. I would have handled it differently if I did. I was too young to evaluate her in that moment. I knew it before I was done, but her husband at the time wanted to get possession temporarily of all of the several kids and wanted the child upon birth to be delivered to him as well.
Mm.
I had never heard of such a request.
No.
And so I used what I called the reverse Pac-Man. I put her on the stand and I had her recite in my terms all the crazy things that he was accusing her of. And I had her describe them in a way sequentially that she very much sounded like the victim in a gaslighting event, series
Okay.
of them. And I confessed to the judge, it sounds awful until you're in the middle of it. And it really is awful. She acted normal in an abnormal circumstance
Wow.
rather than she acted abnormal in a normal world.
I know so
right?
many people listening to this right now are wishing you were their attorney explaining
Well,
their behavior to a judge. Or,
maybe it's attributable to I grew up in a dysfunctional family, and
mm,
you have to survive a dysfunctional family, and you don't know what you're doing as a child. You can listen and learn and watch, and maybe you turn
sure.
out okay, and maybe you don't. I'm sure I'm not okay in plenty of ways, but
Right, right.
I have some empathy for people who are going through it. That's for sure.
This just dawned on me, this question. I want your opinion on because when people say it's their first pass at a judge where they're writing declarations and they're trying to make the judge understand the whole story of the he said, she said, do you usually err on the side of because you'll usually see and I'll just say my clients are usually women, but let's in this model, let's just say the husband's listed all these things that she does. She does this, she does that, she's awful, she's not a good mom, this is why I need the kids, this is why I shouldn't pay spousal support, this is why I shouldn't pay child support, da da da. And I'm always like, don't be the blamer. Just like go in and say, first of all, I ask them how they really feel. And they're like, look, if he would just calm down, I don't care about 50-50. It's fine, but I need him to calm down. Right now, I am afraid for the kids to go with him. And I'm like, then just say that. Say, like, look, I really want this to work out. I'm not calling him a bad dad. I'm not. How does the judge look at those two declarations? Do they even read them? And what's
Um,
your approach when you go into these cases that are high conflict right off the bat? Somebody wants to burn someone down, and the other person's like, can we just?
the person who has the burden of proof oftentimes overplays the burden of proof. You
Okay.
have very little you have to meet to establish the burden of proof. There's some prime elements you have to meet. So you have to have
Okay.
enough testimony to get a TRO if that's what you're seeking.
Okay.
But the other side gets an opportunity very quickly to have an evidentiary hearing.
Right.
I often, when I'm on the receiving end of it, save my story. I don't want to say much more than I need to say. Even if
Okay.
I'm the movement, I say as little as is necessary in writing so that it's absolutely necessary and just a little more than is enough to get it done. Why? You can't take it back. It is a
Mm,
script that a good lawyer can follow. And if you're telling the gospel, if you're being straightforward, ultimately the fact finder, you have an audience of one.
mm-hmm.
And you have to understand you have an audience of one. You're not playing to TV and you're not playing to Oprah and you're not even playing to a family member that will always be sympathetic or a therapist whose role in therapy is to occupy your shoes,
Mm-hmm.
right? And to help you occupy those shoes. You are appealing to an audience of one. So you have to know that audience. Your lawyer should know that audience or know enough to confess he or she doesn't and get somebody on board that does,
Mm,
because that judge wants to know certain things and doesn't care about others.
yeah.
Why? They've heard it all before. Child violence or the threat of it, they want to know about it. If there is a substance abuse problem, they want to know about it. They don't need 50 chapters. They need one or two prime current examples. They want
Okay.
to know why the children are in jeopardy or you are in jeopardy. If family violence is involved, one or two good examples and a couple of photos carry the day. And being believable. Don't oversell your story. You don't
Yeah.
have to oversell your story. You have an audience of one and you have a limited amount of time. You may have 30 minutes. You may have 15 minutes.
Yeah.
You may have an hour, but you've got a limited period of time and the other side gets a shot at you. So your story has to be confined. It needs to be supportable on its own four legs. Think of it like a stool. If you knock the legs out, the stool's going to fall. The story will too. Because once your client is on the stand, whether it be the wife or the husband, they have to survive on their own. You can't
Yeah.
sit there mouthing. It's not like a puppet, a hand puppet. And so they have to live their own story and be able to crunch it down into those few minutes and be believable. If
Yeah.
it brings tears, all the better, but it's got to be believable. It's got to be sincere. You don't have to exaggerate. If you could get a
Right.
TRO, you should be able to hold it.
Yeah.
And if you got it and you can't hold it, then you exaggerated and you're really going to be hurt by that loss of credibility.
Yeah. That is such a good point, not to give more information than you need to. And obviously, back to your point of get an attorney involved, in these cases as soon as possible. So you know what is important and what is not important. And I do tell clients as well, they'll say he or she is lying about this and that and never happened like this. And it wasn't like that, but they sound so believable. And I always just stick with your story. Eventually, the truth sounds like the truth. The
I
truth
make
sounds like the
them
truth.
look at it if there's been an affidavit filed and my client's reaction, whether it be, and I represent an equal number of men and women.
Okay.
I really do.
Sure.
Sometimes it's more of one or the other, but over the course of time, it's even.
Mm-hmm.
I want clients that I can believe in. that I
Yeah,
can help, that I can feel like I'm helping them, not just win a case, but have a better life. And I
sure.
know you do the same thing in the mental health arena. Again, back to being a counselor. I don't tell people to get divorced. Not
Right.
once in 40 years have I told someone to get divorced. It is too personal and too complex a question. I walk them through a series of inquiries to determine whether they have done all that they can do. Do they still want to be married? If so, why? If they don't, if so, why? And have they tried the different things that may be available to recapture whatever it was that had you marry this person in the first place? It's not that I believe in the institution of marriage or the institution of divorce, but I do think in Texas, it's easier to get divorced than it is to get a dog license.
I
And
have a
I walk
caveat
them
to
through
that.
that. You
I think
what?
it should be harder to get married.
I think it should be harder to get married too.
I think if you made me choose, it should be way harder to get married. You should have to do months of classes. You should have to do months of counseling. You should have to fill out questionnaires. You should have to see an attorney before you get married. I mean, let's start that business, John.
I'll go further. I think that if you were going to make it harder, one of the ways to make it harder wouldn't just be go see an attorney or go see a skilled family therapist alone.
Hmm.
Tell them why you want to get married and what your expectations of what a marriage looks like. What do your parents' marriage look like? What are you modeling healthy relationships on? I
Yeah.
would say there ought to be a court that interviews you to
Yes.
determine whether you are mature enough to understand what you're getting into,
Yeah.
both parties.
Yes.
And then if you can pass that, then you can get married. But understand on the tail end, there's going to be an equal examination of why everything you told me the first time wasn't good enough anymore.
Yeah.
What
Yeah.
happened in between?
No, you should have to know divorce state law before you get married. If you move states, you should have to learn that state law.
Well,
I mean,
when people come to me for prenups, they sure learn what the state law is. And it's
yeah.
not just for the prenup. I've represented the money party, the unmoneyed party, the party that wants one, that doesn't want one, for all kinds of reasons. I've talked people out of getting them.
Have
Why?
you?
You both have money, separate properties, easy to identify if you just keep it separate. And if you bring this up now, how's it going to work on this new relationship that you're building? Is it
Mm,
going to be viewed as pretextual? Is it going to undermine your ability to really weave those threads that are necessary to build a lasting relationship? Not
hmm.
every relationship can suffer an early torpedo. A last minute prenup request is an early torpedo.
Yeah.
And I see that a lot.
Yeah, this was not on my list of questions, but I watched a podcast once, on Diary of a CEO, and there was a big family law attorney in New York, the guest, and he did this whole thing on prenups. And I got done, and I'm like, I'm a huge fan of prenups. I mean, like I hear in your scenario, you're like they both have money, just you can track whose was whose and keep it separate.
Mhm.
That totally makes sense. But I was like, oh my gosh, and mainly because it forced people to understand the law and
Mhm.
what happens. And so anyway, I've like did a 180 and I'm like, I'm now a fan of them in a lot of cases.
You know what? In California, in New York, and in a few other states where the collision of the property rights is far more ambiguous and
Yes,
ongoing than it is in Texas.
which is where I
In
got
Texas,
divorced. Yeah.
that's right. In Texas, you've got community and separate property. Your separate property can be identified by account number, and you can have an automatic sweep of the interest because income on community is separate. Income on separate is community.
Hmm.
It's possible to set it up in advance so that there's a community estate and your separate stays separate if you just are disciplined.
Yeah.
That's not necessarily true in California and New York. And so I agree, at the very least, the dialogue of understand this is what you're getting into. Understand if you're okay with it. Trust yourself and the other person enough. Hey, that's a test. Maybe you're not ready yet. Maybe
Yeah.
6 more months of dating and testing the relationship's important.
Yeah. Yeah.
Um,
I
it
agree.
doesn't work for everybody, but it's important.
Yeah, it doesn't work for everybody, but it's important. Okay, so let's get more like specific with Kate when you're in the middle of a case. What
Sure.
communication mistakes do you see people make when they're communicating back and forth and it's a high conflict case?
Temper,
Yeah.
right?
Yeah.
People allow the emotional instigator, the
Mm.
fuel, to ignite. They don't have yet, or they have forgotten the tools that someone like you or me or anyone else might impose upon them, teach them. Use this, have a clicky ball in your hand. I don't care if here's a foam ball, have it in your hand. Talk it out with me first, but no matter what, you are a witness from central casting when you're on the stand, whether it be
Yeah.
in a deposition or in court, and you have to play that role. And that doesn't mean lie. It doesn't mean fake. It means there are ranges of behavior that would be acceptable under the circumstances. If you're loud all the time, no one listens. And so the modulation counts.
Yeah.
And the word choice counts. And I walk people through that with the hope that when they sit down in front of the audience of one, they're actually heard.
Right.
That,
And the
that,
reason
that they're
I want people to hear you say that is there because the fear that the other person is being really loud all the time and that maybe that is getting them somewhere. That fear is real. And so I want them to hear you say like, no, it's loud is not good all the time. And
I took a course in college a gajillion years ago, and one of the things they taught me, I understood it when they said it, but I really understand it now. It's the idea of primacy of colors, primacy of sounds, primacy of numbers, primacy of word choice. All that is true. And what does it mean? You'll remember red before you'll remember white. You'll remember, certain numbers before you'll remember complicated numbers.
you see
Simple
ones,
number,
twos, and threes
complicated.
more than you see sevens,
A
eights, and nines.
complicated word instead of a simple word to communicate the same message. Well, once, you'll remember a scream and a gunshot. What you won't remember is how many gunshots there were when there were 50. You'll just remember there were a lot of gunshots. And so I have found that to be so true when communicating to the audience of one or the audience of 12 with a jury. They want to remember, they want to be fair, they want to do the right thing. The person who is screaming all the time or whispering all the time is forgotten. They're either lost in the noise or forgotten in the silence. In between those two things, that's the reality. That's real life. Real life isn't arguing every single word or screaming every single thing. When you have a clock, I go into courtrooms sometimes and they have a big electric clock, like a scoreboard up on the wall. And if the judge says, you've got 20 minutes aside, I'm telling you, you got 20 minutes aside. Try to communicate a message that you've received in 10 sessions, even though the 10 are repetitive of the same frailties in the marriage in your 20 minutes, which includes the cross. The other side will cross. It doesn't count on your clock, but your redirect does. And you want to put on two witnesses. You want to put your witness on and cross theirs. You got 10 minutes aside.
Wow.
Per witness. You really have it down to have to have it down to primacy. You can assure your client that the rule of primacy really means something. Their screaming all the time doesn't help. When you're communicating a message, you have to reduce it to its lowest common denominator. The loudest person doesn't win.
Right.
The most communicative person, the most relatable person wins. Nine times out of 10.
That's so good to know. And I have a couple rules of thumb I want to run by you. One is I give an analogy, and I use this a lot when they're in custody evaluations with an evaluator. I will say, in 5 years from now, this evaluator won't remember specifically what you said in their meetings, but if they see you at the grocery store, you want them to go, oh, that was that mom that was trying so hard to take care of her kids in that really tumultuous time. Oh, I really liked her when we had that evaluation. So they don't remember what your conversations were about, but you want to leave them with a feeling. And the second thing I tell them is don't be blatant in pointing out, and you and I've talked about this, but labels, narcissism, everything, we do that with all the clients, right? Don't ever do that. But let them come to conclusions on their own. It's so much more powerful. So if you explain circumstances and point out behaviors and patterns, let them go, oh, this girl's a blah, 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 or she sounds bipolar, or he sounds narcissistic. Let them come to that conclusion. It's going to be 10 times more powerful. So those are the two rules of thumb I give them.
All of it's true, because to fail to do it is to sound scripted and insincere. And if you sound scripted and insincere, you will not be, most times, the prevailing party, because the audience of one has heard it before. They can look at a person and they can feel pain and they can see anguish and they can understand circumstances that they've seen a zillion times. And there isn't an equating of, well, he smacked the baby's bottom with, they put the baby's hand on the stove. They are not the same, and you have to understand the difference. I explain it another way. There's an objection in evidence. It's called conclusionary. Objection, Your Honor, that's a conclusion. So if I had you on the stand and you were trying to tell me all about your narcissistic fiance, if that's what he was, I know him, he's not. But if he were, and you just got up and said, oh, he's just a fatal narcissist, it would be as if no words came out of your mouth.
Yeah.
It would be objected to. there will be nothing of substance that would be left with the judge. So forget that it's objected to. There's a story that leads to the conclusion. So you tell the pieces of the story in sequence, and it leads to the conclusion in the judge's mind, the audience of one. Well, that's an effed up person. They may not use the word narcissist. They don't have to have the word narcissist.
No.
They have to know that that person lacks empathy. They have to know that that person lacks an understanding of how to treat others, that they have no self-control, that they have no guardrails on their own behavior, that they overreact to normal stimulus. All of those things can be conveyed through the facts and not the label. The label doesn't help you.
Right.
The label's what the judge gives.
Yep. And so we've already really touched on this about how saying less is the smartest move. And I absolutely love that. And I just had a situation in a case happen recently, same thing. And I heard their attorney tell them that. And I was so excited to hear that because I was like, it was just a quick, going to be a quick hearing with an RFO. And anyway, it was great. I had told her the same thing, but I said, save that evidence for later when there's something bigger. Just get past this one little hump. So anyway, I just want people to think about that and think about, you don't need to bring a gun to a knife fight. I guess.
Well, that's another great way of putting it. You might win that skirmish, right? But they're going to be prepared the next time. There's going to be no surprises. You only won the skirmish because you surprised them.
Yeah.
Well, you can surprise people over and over in trial work because you're holding back what you need until you need it.
Yeah.
I tell my people when they're visiting with court-appointed personnel or amici or guardian ad litems, look, these experienced people, I know them. They're going to ask you and they're going to observe you and they're going to ask you a series of questions. Answer the series of questions in a normal, sequential, and cogent way. Why? Because you don't have to start with, he's a narcissist. You want that third-party professional, if that's the truth, to arrive at that conclusion by hearing the answer to their questions. Let them ask their questions. Your job is to answer honestly and directly and to open doors. You don't want the report to leave the door slammed. You just want it cracked so that when you get up on the stand, you can walk right through that door, or you can walk the amici if they're allowed to testify, or the guardian if they're allowed to testify, or the third party mental health provider.
Sure.
Walk through the door. Did you see A, B, C, and D? Did she communicate A or B or C or D? They'll have to acknowledge they did.
Yeah.
Did they use a label? No. Did they sound like they were scripted? No, absolutely not. When I followed up on it, they had all kinds of historic information that supported the conclusion. This is my conclusion from their historic information and my observations. Every case is a story, and every story can be reduced like Reader's Digest used to do it.
Yeah.
People Magazine. Why is it good for the bathroom? Because you can read a whole story while you're on the potty.
Yes.
Well, being in a temporary hearing is kind of like that. You only get a very short period of time to get the whole story done. That's what you have to be prepared to do. Less is always more.
Amazing. That's exactly how I feel about that. And I you said guardian ad litem. And again, this wasn't even on my question list, but I'm going to go down this road for a minute. In my little world of divorce coaching, the feedback right now from clients, their experiences, their cases, is they have a very bad name, and people will now do anything to steer clear of having a GAL on their case. There've just been so many news stories lately coming out that there's just a lot of dirty ones, whatever. So I'm not asking your opinion, I guess, on if you think that they're good or bad, but if somebody gets one assigned to their case, what's your opinion on how to interact with them? Because I've just had some catastrophic things happen with these people in cases.
I think, honestly, it depends on the court. Know your audience.
Okay.
And it depends on who was appointed and what their role for appointment
of course.
was. And it's always that way with me. I've met one of my dearest friends in the practice when she was appointed in a case as a guardian ad litem. I was in the case for 12 years.
Whoa.
I was originally opposed to her because of the lawyer who brought me into the case. He didn't like custody work. He thought it was a property case. He brought me in. I became friends with her, and she shifted her view of the dynamics, not because I became friends with her, because she was looking at the evidence without being yelled at in the ears. And the lawyer who brought me in could not interact with her without viewing her as his opponent. They're not your opponent from the get-go. Yeah. Now, they may not be skilled. They may not be moral. You don't control that except upon objection, based upon evidence. You can make anyone your ally if you know how, or make them neutral, which is making them your ally in a lot of cases.
Sure.
If they have no opinion, that is contrary to you, you've made them nothing. And
Right.
oftentimes that's the best you can do. Clients bestow too much belief in the conclusion of the third party appointed by the court. I've been appointed as an amici, I've been appointed as a guardian, and I've been appointed as a receiver. I don't love any of the roles because everybody looks to you for too much and too little and blames too much and too little. You can only do the best you can do. And the best way to do it, open and communicative. What would I tell someone who got one appointed? Find out what you can about them, be objective about it, and understand you're stuck with what you're stuck with. But if you
Yeah,
learn who they are, you can learn how to at least make them neutral. You
that's a
can't
good point.
make everybody on your side, but if you can make them neutral, just
Yeah,
make them not your enemy. You've won that part of the game.
I like that angle a lot. Okay, so when people are, this is much more on the counseling side of what you do, but when people are trying to untie the knot or separate, and even if there is a lot of conflict, there's still this dynamic, right? That's at play, like this dance that they've basically, even if it's a bad dance, a dance that they've developed and a pattern that they're in. How do you suggest to people that they start to draw boundaries because they're not going to be together anymore. They're not a couple anymore, even if they're co-parents. And I see people really struggle with stopping these patterns and stopping falling into these patterns that don't help them in the divorce process either. And like, do you understand what I'm trying to ask? Like here, like, how do they
Oh,
start to draw boundaries?
I think that just like you should have to take some sort of training or a test to get married.
Hmm.
I believe with that. I believe I agree with you in that comment. I'm going to draw back to a conversation I'm absolutely sure we had the very first time we met, and we met at a wedding.
Yes, we did.
And I'm absolutely sure that the comment that I made was something along the lines of the following. You asked me how long I had been married because I was still married. And
Yes.
at the time, it was in the mid 30s. And you met my wife.
Hmm.
And we talked later, and you asked me something about what I did for a living. And I think I said to you that the hardest job that I have isn't my job. It's working on your marriage.
Yeah.
It is really hard to be married. It is a full-time job that requires 24/7 learning and compromise. And I am wholly imperfect at it. I'm certain of it. There are days I'm terrible. There are days I'm probably less terrible, and days that I'm pretty good, and everything in between. But it's a full-time job. And the
Yeah.
minute you no longer view it as that, the minute you don't have the aptitude or the skills to deal with that, is the day you have to start working on the second job. How do you be a divorced person?
Yeah.
You're a divorced person. You're
Hmm.
one of the few divorced people that I know that handles it the way it should be handled. So is the gentleman that you're going to get married to sometime.
Hmm.
I don't know whether he was at the beginning or always that was that way, but it is a very rare skill.
Yeah.
Part of it is genetics.
He's good.
Is how intelligent they are emotionally. Part of it is viewing your children as the most valuable asset in the estate,
Hmm.
and being willing to do whatever it takes to subjugate your own self-interest in the moment to make theirs more tolerable, because whatever pain you feel, they feel more. You can't measure what they're seeing or hearing. And I know I said this to you too. You asked me something about being a divorce lawyer, and I said that one of the things that I tell people is when they start to feel their marriage is going sideways and they have children, it is better to have two happy homes than one unhappy one,
Yeah.
because the children, however young they are, can feel what's going on, even if it's not overt. And this is a terrible analogy, and I mean no disrespect by it, but my puppy can feel when the temperature changes by the barometer going down. They have a
Yes.
sense. Children have a sense. It's like a human emotion barometer. They know when things aren't going well, and they don't know how to express it. They don't have the tools to deal with it. And it's our job to teach them that, and life
Hmm.
teaches them it. But during divorce and after divorce, that's our job.
Yeah.
I try to teach my clients how to deal with it, and I start during the divorce. If you start to behave in a certain way, no matter how bad it makes you feel, it will help your children.
Sure.
Whether your husband or your wife, respectively, will in kind come towards that middle road, I don't know. You can't control that. You can simply invite them there. And you
Right.
invite them there by doing it. And it's a little bit at a time.
Yeah.
It's really hard. I can't describe it better than that. But you're right.
Right.
And that goes back to how easy it is to get married.
Yeah.
It
Yeah. It
truly
really
is.
does. It really does. And why I asked the question about boundaries is and this is getting super specific, but I will see clients try to draw boundaries, say as messages are going back and forth, and the other one's trying to keep them engaged because that's how they keep the control going. And they're so worried that they're going to be seen from the court as non-communicative or not sharing enough information about the kids or not responding quick enough or not, and they get very worried about how that looks in court. And I just, I see that they're just trying to draw boundaries. Like, it's okay. You've sent 7 paragraphs of text in the last, day and a half. And I haven't even gotten back to respond to one. And you're yelling at me because I haven't responded to one and I've got 6 more to go. Like, and you can see the other side's just trying to cause conflict.
Well, look, it's back to rule number 1. Less is more.
Yeah.
It always is. And it goes back to the ability to communicate what is most salient in the moment. In Texas, most of the courts utilize a online system called Our Family Wizard.
Yeah. All my clients that are talking parents. Yeah.
Okay. At first, I didn't like it much. One more thing to keep track of.
Right.
I think it's fantastic. Why? Because those that speak too much, it's either pablum, it doesn't hurt anybody, but it's too much.
Yeah.
Or those who speak too much and it hurts them. If the only way you're communicating is through Our Family Wizard or a similar online mechanism that is viewable by the court real time or later, there's a running history.
Yeah.
You will eventually meter your conduct to match the input that's necessary for Our Family Wizard, which requires sharing of all schedules in real time, access to the athletics in real time, academic events or necessities in real time, doctor's appointments, family appointments, travel itinerary. I have my clients make lists before the program's even put into place. Put together the calendars, put together the doctors, you got to put it together just to tell your story. I take them to all the doctor's appointments. Here's what they are. All the dentists, all the haircuts, all the clothing, all the school supplies, all the camp, all the sports, everything. Here's what I do. Here's how I do it.
It's a good point.
Okay, well, soon you're going to have to share it, but it's ingrained. They're already doing it.
Yep.
Whoever the he or she is, they're doing it.
Absolutely. It's, I'm sure listeners are sick of hearing me say this, but I always say less is more as well. And I say, let's just use a visual as an example, because if this ends up in front of a judge, which most of the time it doesn't, but let's say somebody important is looking at it, a GAL or anybody else, and they see 7 paragraphs and they see you respond to the only important information question that's in there with 1 or 2 sentences or even a thumbs up because you agree, that just looks more rational and sane than the 7 paragraphs that are coming every single day. So don't worry about it. Just stick to the plan. Less is more, like you said. Look for the relevant question that they might be asking in the 7 paragraphs, answer it, and try to ignore the rest. And
don't withhold.
Yeah, and don't withhold.
If your daughter has an ear infection, put in what you would expect to receive. What would you want? You'd want to know, I'm taking Susie to the doctor tomorrow because she's had an earache for 2 days and I'm afraid that she needs ear tubes, or I'm afraid she has an ear infection. It's 3 bullet points.
Right.
But you can't be criticized for giving a little more information. You can be really criticized for leaving out the pertinent parts. Saying I'm just going to the doctor tomorrow when you know it's more is insufficient.
Right.
And that's a measure of control. And I understand why a primary parent would need to feel that measure of control in the midst of emotional conflict. But it hurts in the long run, and it really hurts on that post-divorce part. You brought up a point of less is more because I brought up a point of less is more, and you brought up visual. I think every case can be described in a drawing or a series of drawings, and it starts with a timeline. And if you ever talk to that guy that you and I share, he would say that most of the things that we've ever discussed about various clients that we both may serve often start with, after a discussion, I draw it on a big grease board. And I have clients who learn visually far better than they learn audibly. And you have to be able to recognize that as a therapist, as a lawyer. I have to be able to recognize it and recognize it quickly. What is the medium of communication that they learn best by? Simple, clear, primacy.
Right.
Visual. If I draw on the board, it's in a red magic marker.
Right.
Why? You remember it. It's rule of primacy.
Yeah.
I don't have 50 things on the board. I have the 4 bullet points. And then maybe I have 1 bullet point after each. They might remember that. It's visual. They can draw it up in their head.
Mm-hmm.
The same thing applies to you when you have a person who learns better visually. You'll talk to them and then maybe you'll do a drawing of where the power dynamic is.
That's a good point. I like that. I
So
like that a lot. I'm going to remember that. And the reason I specifically asked that question is I have a case of poor woman's been doing this for 3 years. And so when she writes, "Hey, took him to the doctor. He had an, earache for 2 days. So I'll let you know what the physician says." And the other parent moved out of state. Every time she will get back 2 pages of what a horrible mom she is, the reason he got an earache, it's all her fault. He doesn't like the pediatrician anyway, and she better switch pediatricians because he's been going to that one and it's probably the pediatrician's fault too. And he wants a record of what he ate for the last 2 weeks. I mean, I'm not kidding you. This is what happens every time she sends a message. But I want people to listen to what you said, because as long as you keep your side of the street clean, you sent the message, you informed the parent. And I love that rule of thumb, John. Just tell them what you would want to know. That is the best, most
it goes
plain common
back
sense advice I've ever heard.
it goes back to what you and I and every other person that I've ever talked to, even people I don't agree with, treat other people the way you want to be treated. The golden rule, right?
Mm-hmm.
Well, it
Mm-hmm.
applies to everything we do. It
Mm-hmm.
applies to getting married, it applies to staying married, it applies to being in a divorce, it applies to being a parent, it applies to being a divorced parent and a divorced person without children. If you simply apply that and the rule of primacy, just the part that matters, but
Yeah.
always anticipate. That's an anticipation. That's because I've seen it a million times.
Sure.
Well, I wasn't there. How would I know? I just know what I saw when I still lived in town and he or she was a quack.
Yeah.
And this proves it. The tube should have been put in years ago. Yeah, okay, Mr. or Mrs. non-health expert,
Right.
right?
Exactly. Oh
Mr. or
God,
Mrs.
exactly.
who was too busy to go to these appointments.
It's so painful. It's so
It is
painful.
painful,
But
but
that's
there
why
are ways to help.
there are, and there's a simple plan to follow. And again, it keeps your side of the street clean. And I know that it's triggering when they send these messages, but you're doing your job. You provide the information. You're an open and communicative parent, and that's all you can do. And if they want to be crazy, they're going to be crazy.
Well, I'm going to add one more thing to it.
Okay.
I know you tell your patients. I tell every client this, particularly the younger one. Tell my children this, they ignore me. So maybe my clients do too. Maybe your kid does too. Everything you put out into the electric universe is out there forever. And that's not something you and I had to deal with as younger people
That's
when
true.
we had less impulse control
Yeah.
than we do as adults. Girls mature faster. They develop impulse control and advanced intelligence and critical thinking faster than boys do. But nonetheless, a young woman is not as mature and as developed in those areas as a more mature woman. A
Mhm.
young man is not as developed in those as a more mature man. But even the most mature of my clients have to have a regular regulator on their impulse control as it relates to electronic medium. Why? You get a text and it pisses you off. It sets you off. It hits all of your triggering. Your impulse is to immediately respond. Do not immediately respond. In fact, read it, think about it, put it down. Pick it up when you're calm, read it, do an outline, if necessary, of what you need to respond to in bullet point. And when you do respond, don't press send. Think about it. Read it before you send it. And if it's more than an immediate and necessary response, if it's got any emotion in it, definitely don't send it. Or if you're
Mhm.
going to send it, take that part out, because it's like having a dangling modifier.
Yeah.
Worse, it's a dangling modifier that's a self-inflicted wound. That will cut you more than the response could have helped you, even if it's well written.
Yeah.
Not necessary, but we all do it. I do it.
Yeah.
I do less of it now because I regulate myself on the screen. I make myself type it out. Oh, that felt great. I got it out of my system.
Yes.
And now I'm definitely not going to call that person every variant, creative or otherwise, of the F-bomb that I use. And there's a zillion.
Yep.
I'm going to take out those lines and I'm going to just leave it at, I respectfully disagree. And take out the 5 lines of F-bombs and you're an ape and all the other things.
Yes. Oh my gosh. So that is a great note to end on. And I always say a night of sleep changes everything. So if possible, if it's not urgent response, absolutely sleep on it, read it the next day. I started at the last half of my divorce writing myself the emails and not sending them. And then I ended up at the end never sending them because I realized none of it was required. And like you said, unless
It's
you need to
cathartic.
think about it with it. And I look back, and once in a while, there's this private folder I kept. Once in a while, I'll stumble on it, and I'm like, oh, so glad I didn't send those. Like that, it just would not have helped me at all. And here's the thing. If you're entangled with someone that's so good at pushing your buttons, when you send those, they freaking love it. You just took the bait. And it doesn't matter how truthful you got. It doesn't matter how raw you got, how honest you got about what they did and what they've done. It doesn't matter if you provided all the evidence. It doesn't matter. They got you. And I look back through those emails that I saved in that folder, and I was like, he would have won every time, because he got me. He got me to that point.
Well,
He got
the
me
only
riled
thing he
up.
didn't get from you was the cathartic feeling you got to write it. And there
Yes,
is a
right.
self-healing element to it,
Correct.
which is why I say write the
Write it.
draft out,
Yep.
feel that cathartic feeling.
Yes.
I tell them not even to save the drafts because they're discoverable, right?
Okay. Oh,
So if you were on the other side of me and
yeah.
I thought you might do that, a
Yeah.
lot of people keep their drafts.
Sure.
I ask for everything you ever did, plus every draft, plus every discarded, pull it
Yeah.
out from the cloud. So it's a good thing to do. You don't save it and you don't send it.
Ooh, that's a good
Just
lawyer
get it
tip.
out of
It's
your,
discoverable.
that's right.
I
But get it
actually
out
have
of your system. It's cathartic.
I have a funny story about discoverable when I was about to go into a deposition in my divorce, and somebody introduced me to a woman who had been through a million of them in her divorce, and she told me this story about like what to say and what not to say. And so she walks in, she's never done it before. And they spend the first, 15 minutes, what's your name? What are your kids' names? All the stuff they already know, to get it on the record. And then he said, what did you do to prepare today? And she said, well, I don't know. Like, I read through what, your guys' declaration was or whatever. And he said, well, and anything else? She goes, I don't know. I mean, I just took some notes. So I knew, and he said, oh, really? Well, where are the notes? And she was like, I don't know. I just wrote, and he said, are they in your car? Go get them. And I was like, what do you mean? Why? What's happening? She said, never, never tell opposing counsel that you've been taking notes or that you've been whatever, because now they can ask for them. And I was like, what? So anyway, everybody, I'll just end on that fun fact.
It goes further than that. Anything, at least in Texas, anything that you reviewed to prepare for your deposition, they're entitled to look at.
Yeah.
That's part one. And part two is anything you put in front of yourself. If you brought your 3-ring binder, now if all it had in it was the pleadings and nothing else, who cares, right? The exhibits for the deposition, you have a copy, nobody cares. But if you have your little notebook with your notes and your history of emails, they get to have it. They get to cross-examine you on it. So I always tell my clients, bring nothing to the deposition.
Wow.
When they go to court, I say, wear no jewelry. I want you to dress like your Kmart. Don't dress poor.
Yeah.
Dress nicely. No designer clothes, no Jimmy Choo, no jewelry. Everything stays at home, and everything that would have come out of the front of your head that's not complimentary or responsive. Responsive is the key.
Mm-hmm.
Leave that at home too. Anything you take up on the stand, you're going to get to have a meal over. You're not going to get out faster. You're going to end up hours into this down a bunch of rabbit holes.
Mm-hmm.
Leave it at home. When they say, what did you look at for the deposition? I looked at the pleadings and met with my lawyer. And you sit down and you have nothing in front of you. You can have a yellow pad and a pencil. What are you going to do with that? I like doodling. But don't take any notes. Well, what do you need it for? Well, I might write your question down before I answer it because I'm a visual learner. That would be the only explanation for me.
Okay. We stumbled on that piece of gold, but that was awesome. I think that was a fun fact to end on. John Schorsch, thank you so much for joining me on Out of Crazy Town. Everybody, you can find John at JSTX Lawyers. So it's like John Schorsch, TexasLawyers.com, JSTXLawyers.com. And you're awesome. Thank you so much for joining me.
I look forward to maybe someday doing it again. It was a lot of fun.
Absolutely. Thanks again. Okay. Have a wonderful evening, and we'll talk soon.
Have a great day. And if you ever figure out how I can get out of Crazy Town, please tell me.
We haven't. That's why we keep doing podcast episodes. No one's actually figured it out yet.
It's a one-way ticket.
It's a one-way ticket. Oh, God.
Take care, dear.
Oh, thank you.